All right. This is an interesting panel in the sense that we went around and around on this one in terms of like, what are we going to call this thing? How are we going to like stitch together all of these different, kind of sort of different but related speakers, topics. But because there was like so much that happened at the legislature this session around bail reform. We have Melissa here, who is at the Office of Court Administration, and they're like very intimately involved in everything that the legislature is basically directing the courts to do around bail and the public safety reporting system. There's counsel at magistration, first appearance. There's all this action going on before, at the very beginning of a case, before the case is filed. So the best we could come up with in terms of a title was The Evolving Requirements for Unfiled Cases, Bail Reform, and Early Appointment of Counsel. So I'm hoping we captured everything that the panel will be talking about today in that regard. But I think it's going to be very interesting, very timely. Wesley, would you like to take it away?
Sure.
All right.
Thanks, Scott. Yes, we do. We are going to try and stitch this together, and we're going to start from kind of the big picture and then move into specifics and narrower into programs that specific counties have taken on. So that's how we're getting it all under one umbrella. So I'm going to quickly introduce our four speakers, and then we're going to go, each of them will take about 10 minutes, and we're saving a few minutes at the end for questions for any of them. To my immediate right is Bronson Tucker. He's the general counsel at the Texas Justice Court Training Center, where he's been since 2004. They've been a great partner to TIDC on a lot of trainings we've done around the state on the requirements of magistration and requests for counsel, et cetera. Then on the other side, we'll go to Melissa Ostrowski. She's the Bail and Pretrial Program Manager for the Texas Office of Court Administration and has a background in lots of different justice system positions, including as a probation officer, pretrial, magistration officer, just a whole bunch of really relevant experience, also municipal court as well. Next, we'll go to Jeff Burkhart, who many of you already know. He's the county executive for Community Legal Services here in Travis County. And before that was the executive director at TIDC. And then our fourth speaker will be Rebecca Spencer Tavitas, who's the first assistant El Paso County public defender. And she's been with that office for 14 years. And with that, I'm going to turn it over to Bronson to kick us off on magistration.
All right. Thank you, Wesley, and thank you for TIDC for having us here. It's a great opportunity to be here. Appreciate that and appreciate TAC hosting. So obviously, training the justices of the peace, most of them do a lot of magistration work. And so we have had to become, obviously also intimately familiar with how all these things work and how these changes have kind of impacted the landscape of what the process is as these cases come in. Obviously there's a lot of kind of juggling that has to happen. A lot of things are trying to happen all at once when you have someone arrested, and they're getting pulled in, and, obviously if it was a non-warrant arrest, we need a probable cause determination. And either way, we need this person to have their rights read, we need a bail setting, we need all these things to happen, we need them to be informed of their right to have counsel appointed, and we need to get the ball rolling on that, right? We need to get that discussion happening, we need to provide assistance to them in filling out the forms to get that counsel requested, and we need to get those things transmitted to wherever is going to be the person who appoints. Obviously, in some of the more rural areas, sometimes the JP themselves is the person who is designated under Senate Bill 7 from way back in the day as the person to appoint counsel, but in most of the counties, they're going to be sending that paperwork to some other body, some other court, some other entity to get that ball rolling. And obviously that's an education point, right? Because sometimes it's like, yeah, but it's Friday night, right? They're not going to look at it till Monday morning anyway, but it's like, yeah, but you have to do it, right? It has to be transmitted within 24 hours. And a lot of these things have these time frames happening. You know, obviously one time frame is the 48 hours, right? From the statute, they have to have that 1517 hearing where we're going to tell them about their rights. We're going to make a bail decision. All that has to happen within 48 hours. But obviously in a lot of counties, they at least have a policy of it happening within 24 hours, mainly because of the requirement that a person must, if they were arrested without a warrant, must have a determination of the probable cause for their arrest if it was a misdemeanor within that 24 hours, or they have to be released on a personal bond, right? So most jails kind of want to avoid having to mess with that, having someone fall through the cracks. It's like, oh, this person, you know, they were arrested 38 hours ago on a misdemeanor warrantless, and nobody has seen them yet. Now we've got a problem. So most of the time we see the kind of policy of 24 hours happening across the state, and so that puts things on a quick time crunch. In a minute, Melissa will get to more time crunch, right? Because now there's this additional requirement that there's a public safety report that this person is going to be reviewing and using that to make a determination of what that bail decision actually is going to look like. But some of the other things that lean on kind of, you know, where the person's held in these jails, detention centers, that's really kind of putting that in an even more difficult is some of the legislative changes with both Senate Bill 6 and Senate Bill 9 kind of impacting who actually has the right to do these things, right? Obviously, Senate Bill 6 with the Damon Allen Act, that created a situation where when you have people who are arrested for felonies and they have prior felonies, there's different requirements, right? If it's the same county where the original felony was, then only whoever is over that original case can make a bail decision at all. Right? And so trying to get that person to make that bail decision in a timely manner can be very difficult. Sometimes it's difficult to see who that person is, right? I know, like, kind of probably the thought process when the law passed was, oh, well, we'll find the district judge, right, who has that felony, and, you know, that they'll be able to do that. Sometimes that district judge is not available, but also another thing that happens, right, obviously is, you know, I get arrested today on a felony. I get magistrated, say by a justice of the peace, and then I post bond, right? I haven't been indicted yet. And then 2 weeks later, I get arrested for another felony, right? Well, now, when on that new arrest, only the JP who did my initial 1517 can set my new bail also. And so that can be difficult to determine who actually did this, right? Who did this? Where is that person? Or I guess a person designated by that court in writing, right? So some counties, all the kind of people who are responsible for magistrates and the district judges, they will have agreements in writing that, hey, whoever is the magistrate available can make this bail decision, and that's easy, but not everyone wants to do that. Not everyone is willing to kind of give that away, and so sometimes finding that person who is by statute the only person who can make that bail decision, that can be really tough to get that time frame met. A kind of related, related kind of thing that has snagged things up and will continue to kind of be learned by counties, and we've been fielding a lot of questions with the OCA and dealing with that on these things, is the restrictions now placed by Senate Bill 9 on appointed magistrates, right? Magistrates who are hired under Chapter 54 of the Government Code, and those magistrates now can't do all of the magistrate duties, right? They have to basically defer to other courts in certain high-level offenses. And so counties had already kind of had this workflow, right, where it's like, oh, well, this is no problem. We have them go, and this is the magistrate they see, and this magistrate does all of the things, and then they'll get set on the docket, and so then they can go see the district judge and do all those things at a later time frame. Well, now on these violent offenses and other felony type of offenses, there's that wall there, right, where this magistrate actually can't do all the things. And so counties are having to learn, well, how do we do this, right? How do we actually get this person in front of the person who's allowed to make these bail decisions and do that in a timely process. And obviously, since we're talking about felonies, you at least have the 48-hour process. But again, we run around to, but our policy is still 24, even though these cases don't implicate that 24-hour time frame. And so we're getting a lot of questions about, can we have the Chapter 54 magistrate do some of it and then get them in front of the district judge to actually set the bail decision? Is that acceptable to have almost like a bifurcated 15.17 hearing? Can we do that? And so that's really putting some stress on the infrastructure and systems of how counties have designed this process to work. Okay. And so with that, I will turn it over to Melissa to discuss the next step, which is the public safety report and public safety report system.
I'm going to stand. Thank you. Hello. I'm going to talk to you about the public safety report system, the PSRS. How many of you are familiar or have heard of the PSRS? Okay, some. How many of you have heard of the TRAS? Usually, okay. PSRS is not the TRAS. So most of you are saying, what is she even talking about? The public safety report system was put in place a little bit ago. Everybody was telling stories today. And I'm going to tell you a story too. It's not as happy of a story. Bronson was talking about Senate Bill 6, which is also called the Damon Allen Act. So we kind of have to go back in our Wayback Machine to 2017. And Officer Damon Allen was doing a routine traffic stop in Freestone County, and he was shot by the person he had pulled over. And what made this interesting was that particular person had already been convicted of an assault on a public servant, was currently on pretrial bond for assault on a public servant and evading arrest when Damon Allen pulled him over. I don't know if that information was widespread for Damon Allen to know, but after his death, this is when it really started getting on the legislative radar of, does there need to be any bail reform in the state of Texas? And as we are all sitting here, we probably realize that they do. It's important, I think, for magistrate judges to have all of the information they need. Just when you're doing an assessment with your clients as a social worker or anybody else, you want to have all of the information so that you can match them up with the best resources, et cetera, et cetera. So we wanted to do, or they wanted, Senate Bill 6, one of the things that Senate Bill 6 did, was it put all of that together and said, you know what, we want to level the playing field for the state of Texas. And whether I get arrested in Orange or I get arrested in Dallas, those magistrates should have the same access to all of that information to be able to make the best bail decision, not only for community safety, but also for that defendant. So this is the process of the PSRS. You have the person arrested, and then they're processed. The defendant's information gets entered into the public safety risk system. So you'll notice that the R doesn't, or there's no assessment involved in here. We're not assessing criminogenic needs. We're not trying to figure out any kind of treatment we can send them to. We're actually just measuring. I wouldn't even say measuring. We're actually just putting this information in, letting a criminal history run, and then also the PSRS, what makes it different is it'll also tell judges, is this person currently on probation? Are they currently out on parole? What other factors are in there? So it depends on what your jurisdiction is in terms of who's going to be entering in that information into the PSR system. But Senate Bill 6 did require that every county adopt using this system, and its OCA is the office that the legislator made responsible for putting this system into place and keeping it going, and also doing the education for it. So one of the things I think that gets confusing, we were talking about vernacular earlier, the PSRS is your overlying, that is what the system is. When you go and you put information in there, it's going to spit out a PSR, a public safety report. And based on Senate Bill 6, a magistrate judge has to review that before they make a bail decision. So the PSR is produced, it's presented to the magistrate. They go and they have their 1517 hearing, and then depending again on the jurisdiction, it can be a clerk, it can be a judge, they're going to put the bail decision is going to be entered into the PSRS, and somebody's going to certify it. Where I recommended that the judge be the one to certify it because they were the last ones that were going to see it before it got sent to OCA. But again, different jurisdictions. They're going to certify that information that, yes, they read the PSRS, they took all of that information into consideration when they were making that bail decision. That's when after they certify it, that's when that bail form is produced. And then the bail form, once they certify it, that's what gets it sent to OCA. All right, so this is what the public safety report looks like. When it's printed out for the judge, or they can look at it virtually, it's going to give them a whole list of things. Hey, you need to take these things into consideration. Don't forget. Then it has the defendant's name, their date of birth, also gives some information about the current offense. And what I really like about it is that it'll say, is this person eligible for personal bond? And also, does this bail require approval from a judge of a pending felony? So in other words, if I'm arrested for a felony here in Travis County, and then I go get arrested in Williamson County, this is saying, or it could even be the same county, Travis to Travis, do we need to talk with that other judge to let them know this is happening, and that I have broken my pretrial bond conditions, and if any other action needs to take place? So it kind of gives the judge some good information and things to consider, and then also information they may not have had before. It's going to give a printout of their criminal history, and the other thing that I like is that there are applicable conditions, whether it's for that offense or the applicable conditions are mandatory or statutory. It's going to list those there. Once the judge has reviewed all of this, that's when they're going to have that 1517 hearing, and then their bail form will include almost all of this information, including what kind of bail they let the defendant out on, and then how much that was, or if they denied bail. All right, so that was Senate Bill 6. And in this last legislative session, they passed Senate Bill 9. And what Senate Bill 9 does is it builds upon Senate Bill 6. So that's why we needed to go back in the Wayback Machine, understand where we came from, how they tried to make that first step in bail reform, and then some of the things that needed more clarity were added into Senate Bill 9 along with a lot of other stuff, and I get to be the subject matter expert on SB 9, all that is SB 9. So whereas Senate Bill 6 kind of focused on who can be released, Senate Bill 9 is how those decisions are reviewed, clarity and uniformity in handling bail appeals and reporting bond restrictions. There's some other things that are characteristically different. One of the other things that SB 6 did was it required the judiciary who was making bail decisions to take an 8-hour course, I think within 30 days of them becoming a judge, and then every 2 years thereafter. And then to Bronson's point, SB 9 is now clarifying the roles of who can do what, who has permissions to do what when it needs to be transferred or given to an elected judge, etc. All right, so with SB 9, there's going to be a lot of enhancements to the public safety report system, which is always a good thing. I think the more robust information that you're providing a judge, the better decisions they can make. And let me backtrack and say that the PSRS does not take away judicial discretion, but it gives them a tool, just one tool in their toolbox, to be able to make these decisions or to help them make these decisions. All right, so we're already past September 1st, and as of September 1st, the deadline to certify a bail form reduced from 72 hours to 48 hours. So that means that after magistration, they've got to get that submitted to OCA within 48 hours. We are starting to track the 17.151 bail modifications tracking. So if If somebody needs to be released because the state is not ready to proceed on their case, and it depends if it's a misdemeanor or felony, how long. But if people are being released because of a speedy trial issue, we are tracking that now, or I should say the bail form is tracking that now. As of January 1st, prosecutors will have access to the bail forms. It's only and the reason for that is because they have the right to appeal if they feel that the bail is insufficient. But there is a certain criteria that has to be met in order for that to happen in terms of the appeal. Cross-county felony email notifications. Whew, this is a big one, and it's a lot to navigate because so many jurisdictions work so differently. But at any rate, part of keeping the public safe, right, is making sure that if I'm out on a felony pretrial bond and I go and I commit another felony in another county, I think it's important that the original county knows that I've just gone out and committed a new felony, because now they can determine quickly, without having to wait for somebody to notify them, right? They can act now quickly. So as people are entering in a defendant into the PSRS system starting in January, it'll automatically trigger a notification to the county that they're out on pretrial. Also, along the same lines, there will be a notification to district attorneys or their designee if somebody is out on bail for an offense involving violence. And then in April, this is when the PSR gets really robust, because then at that point, the judge will now be able to know, is this person named on a protective order? Does this person have outstanding warrants? Are they on probation, pretrial, mandatory supervision? Or are they participating in a pretrial intervention program? So those are big things and things to consider for the judge. Also, their criminal history will stay in there, but also whether or not they're on probation. Big one here is the failure to appear. So SB 9 says if somebody fails to appear for court and it's willful, the judge has to make a finding that it was a willful failure to appear, and it needs to go into the judgment when that case is disposed of. So on the PSRS, it will let us know if people are failing to report, or it'll let the judge know who's making that bail decision if there was any prior failure to appears. SB 9 also they want to make sure that there's not a lot of double work, right? And so SB 9 said, hey, we want to make sure that all of the jurisdictions have the same access to be able to have their jail system or their case management system interface directly with the PSRS. So if I'm a jailer and I'm the one who's entering into the PSRS when the defendant is first arrested, then pre-trial, it'll automatically update their information. So OCA will have a grant process that we're putting together so that agencies can build an API so that their systems can talk to one another. We're still in the process of developing that. It doesn't go into effect until January, and our website will have more information if that's something that your county needs to have. And I think, yep, that's it.
And next, Jeff Burkhardt.
I'm trying to get this situated here. There we go. Can you all hear me okay? Yes. All right, good. Hey, afternoon. It's good to see you all. I'm Jeff Burkhardt. As Wesley pointed out, I'm the former executive director of TIDC, currently the county executive for Community Legal Services here in Travis County. I was so excited today to see Rodney Ellis. I've been busy like y'all, and I forgot who was going to be on the roster today. And I tell you, I didn't grow up in Texas. I grew up in Kentucky. Lived in Chicago for 17 years and then moved down here to Texas to join the Texas Indigent Defense Commission 8 years ago. And 8 years ago, I got down here, and I'm told, you really need to go see Rodney Ellis. So I drive down to Houston, and we go out for breakfast. We had some waffles, and we're sitting there eating breakfast. And then I run into him in the restroom, and he's standing there, and he's drying his hands forever. I mean, just killing trees. He's like pulling paper towel after paper towel. And you could see it. I was looking at him kind of funny, and he looked at me and he said, "Burkhart, you got to dry your damn hands if you're going to shake hands out there." And it stuck with me. And today, it was serendipitous. I'm out in the bathroom, and who walks in but Rodney Ellis? And I'm standing there drying my hands forever, just killing trees. It was unreal. So anyway, I was surprised and just very happy to see him. So I didn't grow up here, but very happy to be in Texas all these years. When I moved here from Chicago, people looked at me, friends of mine, attorneys and other folks, and they said, "How could you move to Texas? It's so hot. I could never live down there." And then I get down to Texas, and they said, "How did you live in Chicago? Oh, it's so cold. I could never live up there." Whatever you kind of grow up with becomes the norm, right? Whatever you grow up with becomes kind of like the wallpaper. You don't really ever question it. In Texas for a long time, we didn't question the fact that we didn't have public defender offices. That was the norm. Now I think we're getting to a tipping point where we have about 80 counties that have a public defender office or a managed assigned counsel system. That's great. We've made some progress. I'm here to talk about counsel at first appearance, and we're still not at that tipping point yet. We only have depending on your count, about 7 counties with counsel at first appearance in Texas out of 254. But if you go to other places throughout the country, it is the norm already. It's absolutely the norm. Why do we care about that? Who cares about counsel at first appearance? Why does it matter? Why do we want to spend money on that when that's not the norm yet, right? So I've been with Travis County for just about a year and some change. And we do have counsel at first appearance today, thanks in part actually to Bradley Hargis, who's with us here, the head of Capital Area Private Defender Service, who's been fighting for this for years. I'll tell you, Travis County didn't just jump out of the woodwork and just all of a sudden have counsel at first appearance. We tried this about 3 years ago and fell flat on our faces. We made it through, it was 9 days or 10 days? About that, 9 days or 10 days, and then shut it down. And it was a little bit of a failure. I mean, the county had gotten money from Arnold Ventures, the foundation. I mean, it was a big thing, and it just stopped, right? And then there was some finger pointing and all that kind of stuff. But in any case, it didn't work out. Here we are a couple years later, and I'm proud to say we're representing 100% of people today. So all of those, can I have a show of hands? Who lives outside of Travis County is just visiting here for this conference? Okay. So if you get arrested today, you're going to get an attorney. You're going to be in good shape, thanks in part to Bradley and to Katie Jo. So I'm proud to say that. But who cares, right? In a lot of your counties, people don't get counsel when they get arrested. Why does that matter? I'm going to talk about 3 ways to look at that. The first one is look at that through the client's perspective. The best way I've heard our criminal system described from a client perspective is it feels like you're being asked to play a board game, but no one will give you the rules. You're forced to play this board game, but no one will give you the rules. You're being thrown into something. Our job in part as attorneys is to explain those rules, is to help people navigate this system, to get good results for them, right? How scary then when you get arrested for the first time and you're pulled in and you're in front of a judge. And in most of Texas, it's not open to the public. In most of Texas, it doesn't really look like a courtroom. But very high stakes things are happening. They're determining whether you're going to spend the next days, weeks, or months of your life in jail. I mean, that's a big thing. And in most of Texas, you don't have an attorney by your side for that, right? So that's the first lens through which I look at this, is look at it through their client perspective. How much does that matter? And I can tell you again, going back to the wallpaper thing, if you go to some other part of the country where they already have counsel at first appearance, and they've had it for decades, they can't imagine getting rid of it. They can't imagine getting rid of that. And they think it's odd that you wouldn't have an attorney there, right? And I can say from our perspective here in Travis County, it's already made a big difference. I mean, Bradley has a great story. Somebody gets arrested, and when they get arrested, they're beaten and bruised. And if you're an attorney there, you can take a photo. I mean, those bruises are going to go away. That's time sensitive. If you're an attorney there, you can get a photo, you can get evidence there. If you're an attorney there, you can make arguments. You can talk to the client, interview them beforehand. Our attorneys meet somewhere around 10 or 15 minutes, sometimes even up to 30 minutes with the client before they go into court. You can advocate on their behalf. You can argue about probable cause. Was there even probable cause to arrest them in the first place, right? And that's something that doesn't happen in most of Texas right now. So again, I think we're reaching a tipping point in building public defender offices. I don't think we're there yet with CAFA, with Counsel at First Appearance, but I think we're going to get there. This is my prediction. Hopefully we're back in this room in 8-10 years, and we're at maybe 80 counties, 100 counties, something like that. That's my hope. The second lens through which to look at it is through a county lens. There's a great researcher, I think George Nafal is here tomorrow, right? Okay. So Dr. George Nafal, Public Policy Research Institute at Texas A&M, did a randomized controlled trial in 2 different Texas counties. One was Hays County and the other was Potter County. If you're not familiar with randomized controlled trials, this is what we do in medicine all the time, right? You give some people the medicine, you give the other placebo, and that way you can measure the difference, right? Same thing, you have a treatment group and a control group, and in this case, the control is you don't get an attorney. The treatment is you get an attorney and you measure the difference. And George did exactly that in those 2 counties. This study is available online. So look at the Public Policy Research Institute's website. And you can see it really made a difference. And actually, it was interesting. It made more of a difference in Potter than it did in Hays, at a place that you had kind of low pretrial release rates. You get attorneys there. The idea is that you have a better sort, in a sense. You're releasing people safely, a larger number of people that you might be able to than you might otherwise release, because you have an attorney who's able to talk to them and make some arguments. So there are jail bed days savings to be had in many counties if you look at that. But talk about greater trust and accountability, that we're treating people so responsibly. They have an attorney right from the jump, right? Also, as a quick side note, it helps as a defense attorney to develop that relationship so early on and continue with the client on. You build credibility, you build a relationship, it's a big deal. The last way, though, we talked about clients, we talked about looking at it as a county. The last way I would look at this would be through a constitutional lens. And we have, so Jordan here, Jordan, if you can raise your hand. So Jordan is our recent, actually, can we have a round of applause? Jordan just passed the bar exam, so. Jordan hates when I embarrass them like this, but it's, and is heading out to Concho Valley, out to Elizabeth's office, and I think it's just another week, right, or this week. I asked Jordan to do some research on Counsel at First Appearance. There is not, the Supreme Court's not weighed in on this. Rothgary versus Gillespie County, which came out of Texas, 15 years ago now, is it about right? How many? 2008, thank you. Probably the closest decision we have. We've had multiple cases go up to circuit courts. Booth versus Galveston here in Texas, the Davis case. We have a case pending in the 8th Circuit, the Farella case right now. There's a case, I believe, pending in the 9th. Is it Alarcorn, I think? But the U.S. Supreme Court's not ruled on this yet, right? There's not a mandate to have Counsel at First Appearance. It's really clear coming down from the Supreme Court right now. We do have a little bit of a circuit split on this. But we do have active litigation in this. And I, without commenting on the actual substance of this, we here in Travis County have been sued by the ACLU for not having Counsel at First Appearance. I can't comment on that lawsuit. It's not yet settled. But I want to throw that out there. That is an area of active litigation too. So those are 3 lenses through which I would think about this thing. 1 is through the client's lens. 2 is through the lens of a county. How can it help you as a county? And I believe it can. And 3, through the lens of the constitutional law, which is still developing, right? In the few minutes I have left, I just want to give you a little bit of a glimpse into what we're doing in Travis County, because I think it's a little different than what most counties are doing for Counsel at First Appearance. We only have about 7 counties with Counsel at First Appearance out of 254. Harris County, I think we have Harris County folks here still, do we? Oh, we do, okay, yeah, we got some here, yeah. So we got a couple of Harris County folks here. They have Counsel at First Appearance provided by their public defender office. We have Fort Bend. We have, so about 7 or so. What we've done differently in Travis County, 1, we spent a lot of money on it, which you don't necessarily have to do. There are cheaper ways to do it than the way Travis County has done this. When we looked at Counsel at First Appearance, we used it as a chance to kind of look at magistration and do a total overhaul of magistration. If you look at magistration, a lot of times it's like the seedy underbelly of our criminal system here in Texas and in many other places, right? It's behind closed doors, oftentimes not in a courtroom, not on record. I mean, there's a lot going on, and we started to peel that back. And, you know, things weren't great. We had a lot of work to do. We're still not there. But we've made a ton of improvements, and I want to talk briefly about some of those. One is that we opened magistration up to the public and put it in an actual courtroom. So you can, right now, I mean, it's going on this moment. I don't know if it's Bradley's attorneys or our public defender or who it is right at this moment on this shift. You can walk down the street, about 6 blocks, and you can walk in there. If you have time, go do it. They'll be there till 11 o'clock tonight. You can walk in the first floor of our Criminal Justice Center and watch counsel at first. You watch magistration, see counsel at first appearance in action, right? Because it's open to all of y'all, open to the public. We also moved away. We had municipal folks serving as judges. We moved away from that, and we have county judges. We added interpreters. We have a Spanish interpreter at every single shift. For us, that was important, and we're a bigger community. That's not realistic for every county that's out there. I get that. For us, between 14 and 17%, something in that ballpark, are primarily Spanish speakers. And so having those Spanish-speaking interpreters in person has been a big deal. We still have to rely on Language Line for other languages, of course, that pops up. But that, far and away, is the largest language group for us. We also had to create a new office. You know, and I'll tell you my version of this. Bradley might remember differently, but I came to Travis County a year and some change ago. I went to the chief public defender, Adiola Ogunkede, her office handles 20% of the cases roughly. And I said, and we at that time, actually, even before I got here, we were already kicking the tires. Bradley and Adiola were already kicking the tires on counsel at first appearance. And I said, Adiola, we're doing test shifts right now. When we get to 100% of people getting counsel, what percentage of cases, what percentage of people can you represent? And she said, quite principally, so she said, our office will only do vertical representation. In other words, we will only take cases where we're going to represent somebody all the way through the end of adjudication. So 20%, maybe 25%. So I go to Bradley. I said, Bradley, hoping Bradley might say, yeah, I'll take the other 75, it's fine. Bradley, do you want to take the other 75? And Bradley, very reasonably, said, you know, we've lost a lot of attorneys. And I think most everybody here has lost attorneys on the list. Travis County, we've gone from about 250 lawyers a decade ago down to about 125, right? That's a huge drop. So Bradley said, I don't have the lawyers to do that. And he said, maybe I can do 25%. I'm not a math major, but that seems to leave half of all clients out in the cold. So we created a new division, the Office of First Defense, staffed that up, 18 staff, including 13 attorneys. Thankfully, the way we staffed up, we do have a Spanish-speaking attorney, too, on every single shift, which is great. So we've made a lot of changes. I could go on. We've added sheriff's deputies. We've added pretrial folks. We've added clerks. I mean, it's been a big investment for Travis County. And we did really, I mean, we keep on saying CAFA as a shorthand. We did a total magistration overhaul. And, you know, I think we have one of the better programs in the state at this point. We're not perfect. We're far from it. But we have gotten better and better. And if you want to see something that looks, I think, close to what you'd see in most of the rest of the country, Travis County's about there. Not perfect. We've still got some work to do. And I would encourage you to come see it. But again, you don't have to do all that to get counsel at first appearance. What you need for counsel at first appearance is attorneys, right? Attorneys at people's side. So if we can be helpful, please let me know. And thank you all for being here. Thanks for listening.
Good afternoon, everyone. Oops, didn't mean to turn it off. Can y'all hear me? Can you hear me? Okay. Rebecca Davitas with the El Paso County Public Defender's Office. The gold standard, the dream. I get to speak after Jeff about the alternative. Very much like Jeff stated that initially they made the attempt of getting representation at magistration and it failed. I'm sure Bill could tell this story better than I because he was a part of that when we went through all of the hoops, brought everybody to the table to say, we want to do representation at magistration, and we were almost there. And one person said, I changed my mind. So what's the alternative? The alternative is what we call 48-hour bond hearings. And at that time, El Paso said, we want to make sure that we are not keeping poor people in jail because their bonds are too high. We really don't want to be named in a lawsuit, so this is why we're going to do this. And that was back in 2019. We were set to go live April 2020. That date was set well before we thought or knew that COVID was coming. COVID hit in March. We still said we're moving forward. And fortunately, happy to say that despite COVID and all the changes that were going on and how the world shut down and we were thinking, how are we going to make this happen? We made it happen. And we've been having our 48-hour bond hearings since April of 2020. And obviously that couldn't have happened without the help of TIDC, where we applied for an improvement grant. In that grant, we applied for a senior trial attorney, a legal secretary, and a part-time secretary to work on weekends and holidays, in addition to an indigent defense coordinator. What we had in mind for 48-hour bond hearings, or the plan we made, was to have 48-hour bond hearings 7 days a week, 365 days a year. Now, keep in mind, magistration in El Paso happens 24/7, so there's always a magistrate on staff. Bond hearings are held Monday through Friday, every Monday through Friday at 8:30 in the morning. And on Saturdays, Sundays, and holidays, they happen at 10 o'clock in the morning. We have one full-time employee who works Monday through Fridays, and we have employees who sign up for shifts on weekends and holidays. The attorneys. The part-time employee works every Saturday and Sunday and holiday as well. The way that the process goes in El Paso County is when someone is arrested, they obviously get taken to the jail, they get processed through the mental and medical health screening, and immediately thereafter they meet with a pretrial service officer who interviews them. The pretrial service officer completes a risk assessment, and immediately thereafter they're taken before the magistrate. Now, before the magistrate, the magistrate has a complaint affidavit, their risk assessment, a copy of the rap sheet. One of the changes we made in El Paso County is on the magistration forms, we added a paragraph so that after their warnings are read, and once they're told if they cannot afford an attorney, they could apply for one, and if they qualified, one would be appointed. We also added the paragraph, or that was already included in the paragraph in the magistration warnings, but one of the paragraphs we added was, if you are still in jail 48 hours after the time of your arrest, the public defender's office will represent you for the sole purpose of a 40-hour bond hearing. So a lot of our clients will tell us, thank God they weren't lying to us. We do have a 48-hour bond hearing. They said you would be calling us. Yes. So everyone in El Paso County that gets arrested and they are still in jail 48 hours after their arrest, they have a bond hearing. Now, our attorneys, what they do, or our attorney Monday through Friday and our weekend attorneys, what they do is the evening before bond hearings, what we receive to prepare for those bond hearings is the risk assessment, and I'm happy to announce that we have recently successfully had the opportunity to ask, and we have now received a copy of rap sheets. I don't know how many other jurisdictions here receive rap sheets. I'm curious. Harris County does, Travis County, which we definitely named. Anybody else? I'm curious. Tarrant County. Okay, how do you all receive those? I'm curious.
Ours is through like a risk assessment. That's how we do it. It's similar to TLEX what we use.
Okay, but is it electronically? Is it paper? Electronic. Okay, and does the DA's office provide that to you all? Or pretrial service?
Pretrial.
Okay. And go ahead.
I received it through the sheriff's department.
Interesting. Okay. And I asked this question because this was such a big deal for us. We never got rap sheets before. We would get a brief summary but never rap sheets. And so, I mean, oftentimes DA is reading off a rap sheet in a bond hearing, and some of the clients would blurt out like, "That's not me, I didn't do that." So very important, and I encourage all of you, advocate to receive rap sheets, because we all know they're not accurate. So we get to review rap sheets, risk assessments, and complaint affidavits before bond hearings. Monday through Friday, we interview our clients at 4:30 in the morning. We set up a system because we created this right when COVID hit. We were very fortunate that the jail worked with us to schedule telephone interviews with our clients. So every morning at 4:30, we are interviewing our clients. Yes, sometimes they're half asleep and not very happy. But then when we tell them, no, we're here to help you and try to get you out of jail so you can get home to your family, they're a little more responsive. So we interview everybody at 4:30, and then we have our bond hearings at 8:30 in the morning. On weekends, it is a little bit different. Friday afternoons, we interview our clients telephonically, and then we have our bond hearings at 10 o'clock the next day, Saturdays and Sundays. And then on holidays, we interview at 8 o'clock in the morning, and we have our bond hearings at 10 o'clock. Ultimately, our interviews are very brief. Unfortunately, we don't have a lot of time because the jail is short-staffed. They have been short-staffed since COVID hit. They have been generous, I think, to allow us to have these telephonic interviews. I wish they were in person, and I hope that one day we will get there. But for now, we are making sure that we have a place for our client to live. We talk to our clients, ask them, do you have a place to live? The standard things that we look for in bond hearings to ensure that the judges know our clients have a place to live, if they're working, if they have children, families, mental health issues, military. In El Paso, we're fortunate. We've heard a lot about mental health, and I do think that our jail magistrates in El Paso are very sensitive to mental health. So, and it's very sad. Our mental health population, especially after COVID, it's very high, very, very high. So we're very familiar with the resources in our community that help our mental health clients. So most of our jail magistrates are considerate of that, and they know that we will ensure that our clients will get the mental health attention that they need, in addition to the fact that we do have social workers in our office. Now, if you're wondering, what about their court-appointed attorneys? Typically, any client that applied for a court-appointed attorney, at the time of their 48-hour bond hearing, they're notified whether it is our office or somebody from the private bar that is their court-appointed attorney. So the clients will know by the end of their bond hearing who their court-appointed attorney is. Our success rate in getting people released from jail is very high. I believe last fiscal year, about 72% of people were released, and out of that 72%, about 41% got PR bonds. So very, very good success rate in terms of relief. Definitely some jail cost savings. I would love to say that we are there at magistration to make sure that those 2 days get taken away and clients get to get out and be back with their families, and the county saves some money, but eventually we'll get there. Now with SB 9, this is all new, and I didn't really have good numbers. I believe that since SB 9 has gone into effect, about a quarter of our 48-hour bond hearings has reduced. So in El Paso, what we are doing with SB 9 hearings is everybody has a 48-hour bond hearing, and at 11 o'clock, actually 7 days a week, SB 9 settings are happening. And El Paso County realized that for those SB 9 settings, sadly, a lot of people are getting what we all knew, people would get stuck in jail. So El Paso County has decided to ensure that those individuals who didn't have a 48-hour bond hearing, had their SB 9 setting, but are still in custody, they have hired a visiting judge to have, or to hear, bond hearings for those SB 9 individuals once a week, every Friday at 3 o'clock. So alternative to the gold standard. That's what El Paso County adopted. I hope one day I'll be here telling you all that we now have representation at magistration. Common theme today, I think, that we heard is human beings, lives. It could be our brother, it could be our sister, mental health. And at the end of the day, we're here to protect each and every one of those rights and making sure that they're taken care of. So thank you so much.
We've got a few minutes left, and we'd love to have any of your questions for our panelists. And as we've evolved, Judge Board.
The place I'm seeing people fall through the cracks is when they're detained on a motion to revoke or a motion to proceed. We finally convinced the JPs they still had to magistrate them on their right to counsel. But because they can't set the bond, it was their opinion that, they weren't going to do that. But we talked them into that. Now, though, people are languishing out there that are bond eligible, and no one's considering, the district judge or the county court of law judge isn't considering a bond. What's the best practices to try to correct that?
Yeah, I know for sure we've addressed that the part you were talking about as far as the motion to proceed, those kind of things. What we will call it for the judges in the classes I've taught anyways, you got to at least give them the welcome to the county speech, right? Which is like, here's why you're here. You're here until you can see Judge Smith, who has revoked your probation, and they've said no bail. So you're gonna be held until you're in front of them. Do you currently have an attorney? Do you need to have an attorney appointed for you and go through that process? So for sure that's the case. And so you said now they're falling through the cracks after that period of time?
Well, our judges aren't prejudging whether they're entitled to a bond or setting them one, and then they're getting magistrated on their right to counsel, but then no one's ever taking them before the judge who can set the bond to get one considered.
Yeah, no, and so obviously there's ultimately a time frame, right? I believe it's 20 days where they have to be brought before the judge who had that, and so obviously better for everyone that it's not the full 20 days, right? We'd rather go ahead and get this process going. And so from my perspective, and I'm certainly would love to hear everyone else's also, but is, just trying to come up with that communication flow of when we have this person, how do we alert whoever is going to need to know this person is there, so we don't lose them through the cracks. It's kind of the same that we've seen on the 17.151 situation where it's the release because of delay. And, all of a sudden it's like, whoa, this guy's been in jail for 162 days and that's 72 too many. So I think, especially obviously, electronically now, trying to have some of those electronic reminders when someone's booked in and have a system set up where there's a trigger, where there's an alarm, where it's like, hey, we need to know what's going on with this person. Yeah.
One other item we've seen that frequently is a disconnect since the court that issued that motion or the warrant on the motion to revoke also frequently has the request for counsel going back to them, is to remind the courts that the same time period, if you're a 3-day county or you're a 1-day county, counsel has to be appointed. And then knowing you're running a MAC, but whether it's a MAC or it's a regular public defender's office or it's the panel attorneys, reminding counsel that they can always file their 20-day motion or file a motion to get before the judge to set bond.
Other questions? Yep, got one in the back.
I'm Susie with Cherokee County. So I've heard a lot about appointing counsel, I guess, for the incidents that do want it, but what about the ones that are refusing counsel?
Yeah, I mean, there's a, Freda versus California says that you have the right to represent yourself. So, that doesn't worry me so much. I mean, if somebody absolutely wants to represent, it does worry me, I shouldn't say that. But what worries me more is sometimes when I was at TIDC, we would see systems that discourage people from getting counsel, that kind of nudge them away from requesting counsel. That worries me more than people exercising their right under Freda. So you do have an absolute right. I mean, you to represent yourself to refuse counsel. Not much you can do about it if people refuse it. I worry more about the systems that we put in place that sometimes deprive people of counsel and nudge them away from it.
And I guess the only thing I would add to that is for sure just making sure that they're at least knowingly and intelligently making that decision, right? Like, obviously when you have a person who's picked up on, they're clearly heavily intoxicated or mind-altered state, and they're like, well, I guess they said they didn't want it, so, following back up with that would just be the thing that makes sure that anytime they're waiving rights, we've seen that sometimes with counties, right, where it's like, here, these are the papers you sign for jail and to get out of jail, and in that is like, also you agree that you don't have this right and this right, and so obviously that's a problem.
And Bronson, you triggered I'm glad you said that. You triggered a thought. If you look at that sorry, it's a little sensitive. There we go. That Hayes County study of counsel, just zooming in on counsel at first appearance for a minute. What was so odd about that study, when you look at people who had counsel, we'd say days where people would just say, no, I don't want a lawyer. And then we tried to drill down and see, well, what was the common theme? And the cases were wildly different. They weren't arrested together. They didn't know each other. There was a mix of felonies and misdemeanors. There was no common thread. And then what the researchers finally kind of discovered was when the first person who popped up, if it's a group setting, and they're all talking about the right to counsel, the first person says, I don't know if I want that. No, I don't want an attorney. Then everybody else kind of followed suit. There was no other common theme. And what a weird thing. And so I think understand, to your point about, knowing an intelligent waiver, that's hugely important to really describe what an attorney provides you.
I actually want to add one more thing too, because yes, they can say no, they don't want counsel. Sometimes that's because they think maybe I'm going to hire counsel. So the best practice really is to follow up and see, did they hire counsel? Particularly if you're defendants who remain in jail. You don't want them sitting around for weeks, waiting for the prosecutor to file the case and get before the district judge. If they're still sitting there and they don't have counsel, that's probably a problem. And going back and asking them, I know a lot of places have a process where they keep track of their, the folks who remain in jail, and maybe in a few days or 1 week they go back. And if they don't have counsel yet, ask them at that time, would you like to request it now? Because they may have changed their mind.
Yes, I was appointed as the magistrate judge in Fort Wayne County back in January under Chapter 54 of the Government Code, only to learn effective September 1, I can no longer release anyone on bail for certain types of felony offenses. And so we began to speak to other counties around the state who were scurrying around because they also had Chapter 54 associates. I'm just curious, how did you all resolve that issue, if you had that issue?
Oh, no, I said I was going to defer all of the.
It was prearranged that chapter.
Okay.
Yeah, no, and absolutely, this is certainly a situation that a lot of counties are struggling with, and to be honest, I don't think I have an answer yet to say how it's been ultimately resolved everywhere, because everyone's kind of learning the brave new world of this. Some counties are having the Chapter 54 magistrates, at least, that is their preliminarily thought out process. Is the Chapter 54 magistrate is evaluating the probable cause, reading the rights, doing all those things, and then basically there's a bail hearing that is set for the district judge or whoever has the authority, where they'll ultimately make the bail decision. Some of the counties are talking about, can the Chapter 54 magistrate make a recommendation to the district judge, where then the district judge is making the bail decision, but all the legwork has been done. And so, we would say those things are within the statute, yes. One question that has come up a lot is, as long as you do that within the 48 hours, can that subsequent bail hearing, can that be later than the 48 hours, right? And our answer has ultimately been no, that entire process needs to occur within 48 hours of arrest to include the bail decision. But I think counties are still kind of mulling this over, and it's kind of the same thing where this is the system we set up. We've hired people to do this, and now some of the ability to make those decisions has been cut out. So counties are struggling. You're not alone in that, if that helps any. But I think we'll see as this continues on what counties find as the best way to handle that.
Isn't there a difference between 54 and 54A?
Oh, yeah, good point. So, yeah, there is a difference also. We get this question on, there's Chapter 54A of the Government Code, and the legislature, when they imposed these restrictions, did not impose the restrictions on judges appointed, magistrates appointed under Chapter 54A. And so that's something the counties also have to look back and say, hey, okay, what process were we actually following? Were we authorized under 54A or Chapter 54? And so, we'll see if that loophole gets closed or if that was an intentional decision or how that works. But that's a great point that Chapter 54A magistrates are not currently restricted on how they can release defendants.
And that's what we're doing. Each morning, each day I review them, and if I find what we're calling an SB 9, then we refer that to the district court judge, who can assign that to his 54A. Either he'll do it or he'll assign it to his 54A. So we see them every day. We start at 10. I handle everyone that I can handle, and then the judge will come on via WebEx, and either he or his associate will handle all of the SB 9 referrals.
Mm-hmm. Yep.
And we do have a public defender who is there representing it, and it does make a difference in terms of the number of cases that no problem cause is found, or they make an argument that was an PR problem. So it's good to have them there.
We've got time for one more question if there is one, and otherwise we'll wrap it up and thank the panel. Oh, whoop, we do have one more question.
You said you had 20 days to hear for a revocation. What statute is that? To hear, like if there's a no law? Do you know what statute that is?
I don't have the number off the top of my head. I know that that's basically when someone's on the motion to revoke, when they're arrested, they can be held until they're brought before the judge who issued the order, but there is a limit on the 20 days. I want to say it's actually in Chapter 42A, I believe, not Chapter 17, but I can't recall the exact section off the top of my head. I will say on our website, tjctc.org, we do have a desk book that's a magistration desk book, and we have forms, flowcharts. We're updating the desk book currently. It hasn't had the new legislative changes that should be posted with the new stuff within the next 6 weeks or so. But all that stuff, it's not behind paywall or anything, and I know it's in there. The tjctc.org is our website, and it's on our legal resources, desk books. We have desk books for all the different duties that justice courts have, and we have a magistration desk book that goes into all the nuts and bolts. Thanks.
Thank you.